This is Michael Popok. Check your watch. It's time for Legal AF After Dark. And what else is dark? The days of Donald Trump. Judge Merchan is going to be sentencing Donald Trump. Oh, no finer words have ever been spoken. For his 34-count felony conviction on the 18th of September. You know how I know? Not mental telepathy. Orders of the court that we've broken down and analyzed, and we did it on Legal AF, the podcast. Take a listen. You want to stay let's stay in New York. Let's stay in New York for a moment and transition. There's no segue for that, so I'll just have to go.
Sorry.
Right. No. It's okay. It's a good story. It's a good event, not a story. It happened. It's a good life moment. So Judge Merchan issued, to remind people of how things work in New York, where Karen and I practice regularly. We do a lot of things by letter, which to outsiders is like, really? Isn't there like a more formal document? Nope, we like letters. And so when you want to file a motion in a criminal or civil case, you file a letter request. Sometimes you ask the judge to just treat the letter as your motion, and then the judge gets around to sending you an email or a letter. I mean, lots of things in the Judge Engoron fraud case were just done by the judge emailing the parties, and that constituted formal action, if you will, of the court. So it came as no surprise when on letterhead addressed to one of the lawyers for Donald Trump and one of the lawyers, Emile Beauvais, and one of the lawyers, Josh Steinglass, for the Manhattan DA's office, Karen's old stomping grounds. Judge has woken up out of whatever summer hibernation people thought he was in, which he wasn't, and has said, all right, I got a lot of things in front of me. I got a motion to disqualify me filed again for the third time. And I've got a request for another round of briefing by Donald Trump on that. Let's put a pin in that for a minute. I've got an immunity decision. Donald Trump has filed a motion to vacate the verdict of the 34 felony counts on the immunity decision, even though all the conduct was really before. Most of it was before, if not all of it was before, and some evidence maybe after he was president. But how does the immunity decision from the Supreme Court even map onto this? But there's briefing about that, and that's sort of complete. And I got to make a ruling on that. And then I got to talk about sentencing, because I pushed this sentencing off a couple of times already, because the convictions happened. And even though the appeals haven't happened, that's not how that works. You sentence, and then if somebody's got an appeal, they can go take that whole thing up to the appropriate appellate court. So Karen, you want to talk about the couple of page letter that Judge Merchan issued and what it means in terms of things that the Meidas Mighty and Legal AFers should be focused on in terms of milestones coming up, because it's all going to be relatively quickly, a couple in August, a couple in September, to catch him up as to what Merchan's doing with all these things.
Yeah. So the thing about the letter that I found to be most heartening and significant is that there is a sentencing that looks like it's happening in September. People were slightly concerned because there was when Judge Merchan originally postponed the sentence, it was also in writing. And what he wrote was, I'm adjourning the proceedings to September 18th, and we will proceed to sentencing if necessary. And that gave a lot of people concern, because what do you mean if necessary? Why wouldn't there be a sentencing? But Judge Merchan is just a very careful person. He speaks and writes very carefully and very deliberately. And what this letter, I think, really solidified is that it looks like there will be a sentencing. He writes at the very end, please note the court appearance scheduled for September 18th at 10 a.m. remains unchanged. We will proceed on that date and time to the imposition of sentence. It says, or other proceedings as appropriate. So he's, again, still kind of slightly hedging, but a little less. And so I thought that was good. He's still intending to go proceed to sentence. He told the parties to file their sentencing motions, which is common in cases, especially of this magnitude, especially when there has been a trial. What normally happens is lawyers will write what's called a sentencing brief, where they put in anything they want the court to know to take into consideration during sentencing. They can be hundreds of pages of long. You can attach letters from the community asking for leniency. You can, if you're the defendant, you can attach letters from medical records showing that you have some kind of medical problem and therefore please show some leniency and mercy, or whatever it is. That's the time for the defendant to put in all of the reasons they think that they should be given a lesser sentence, or what they think is appropriate. And the judge will look at, are they contrite? Are they apologetic? Are they, all of those things are things that the judge will take into consideration. And of course, the prosecution does the same thing, where they put together a summary of why they think the person deserves X, Y, or Z as a sentence. So the judge has asked the parties to, if they, it's not required, by the way, to do that. You can also just show up at sentencing and make an oral speech, but a lot of people like to put it in writing and make their case in both orally and in writing. And so the judge specifically asked the parties to do that and gave them a deadline for that, for when if they plan on doing that. And the judge put a few more dates in there. He basically said, he summarizes where we are and what's going on. And he specifically tells the defense, who wants to submit another reply to the recusal motion, right? They submitted a third recusal motion, as you said, the prosecutors reply. And he said, essentially, I don't need you to reply again. I have enough information. And he's going to deny that. He's denied it several times. There's no reason he would grant that. But he'll resolve that. And then the 330 motion, which is the motion to set aside the verdict based on the immunity decision, that's going to be a slightly more involved. I think he's going to I think Judge Merchan has been quiet, as you say, for a while, but I think what he's been working on is applying the law from the case, right? The immunity decision that came down from the Supreme Court to this case. And he's going to write a significant decision. Unlike the Washington, D.C. case that we're going to talk about, that one has not had a fact finding, right? There's not been a trial. There's not been a hearing. This has had a full blown trial with evidence, with witnesses who've been cross-examined. So the judge has a full record to apply that new law to those facts to determine what, if anything, comes out, and what, if anything, happens to the case, and whether or not it's harmless error, which I think is ultimately what he's going to find. So that's what Judge Merchan has been doing and will be doing. And we're going to see some deadlines come up where things are filed, but essentially what we're going to really, the time to show up is September 18th. That's going to be the sentence. Unfortunately, it's not going to be audio or video recorded or broadcast. So we're going to have to rely on stuff coming out of court, like we did during the trial.
Yeah. Just a couple of color around what you just said. So I think on the immunity, you're right, because the case has already been tried, the evidence is already in, the record is already established. It's going to be relatively easy. Even Trump's not trying to argue that his actions were immune. What he's trying to argue is, under some other parts of the immunity decision, that certain of the evidence relates to official conduct while he was president. So the whole of the conspiracy to pay off Stormy Daniels was before the election, because it was done to suppress that information so Donald Trump could get elected. That's what everybody testified to, including, of course, our fellow podcaster and friend, Michael Cohen. There was some leftover economic entanglements that extended beyond the election and even the swearing in, like private checks that had to be written on private Trump checkbooks, on invoices that Michael Cohen submitted to pay off the scheme that was already established before he was president. It doesn't make it a presidential act, just because, which is what Judge Hellerstein said, the federal judge, when he looked at this issue once before related to some of these things. He said, so the issue is whether any of that evidence was, if it came in, was it outcome determinative? In other words, did the jury rely on a couple of stray pieces of testimony by people that worked in the White House, like Hope Hicks and the woman that was responsible for his agenda and the revolving door in front of his office for scheduling, whether that was the reason the jury convicted him of 34 felony counts. And that's to your harmless error point. The answer to that is no. I mean, even if it shouldn't have come in because it was official conduct that the Supreme Court has said should never be used in a case, it doesn't mean if it is used, it either falls into reversible error because it was outcome determinative. It made the case. Or it's reversible error. It's just something that, all right, shouldn't have happened, but didn't have an impact on the actual outcome. And I think that's where the judge here is going to go. I think he's going to issue that in September the way he said. He's going to dispatch that. He's going to deny the motion for recusal. Donald Trump's lawyers asked for, they're always so greedy. Can we have one more brief? And the judge said, on the issue of you being disqualified because your daughter works for Democratic fundraising causes. And the judge is like, I don't need any more briefs. This is the same arguments you've raised in the past. He didn't say that last part, but that's what he meant. And so he's going to deny that. And then we're left, as you said, Karen, just what's there glowing on a bright calendar is going to be this September 18th sentencing. And there will be sentencing. So for those that are there's an interesting split screen that I'm going to show you next before we take our first break for commercial and talk about what the Supreme Court didn't do to help out Donald Trump recently. Welcome back. That is a podcast that we started 4 years ago called Legal AF. We sit at the intersection of law and politics so you don't have to. We bring it to you the only way we know how, the only way on YouTube, as practicing lawyers who know what they're talking about in these courtrooms and at that intersection. 3 or 4 stories curated every week on Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on this YouTube channel, and then on every audio podcast platform of your choice. If you know about Legal AF, we thank you for being part of our audience. We're trying to grow organically along with the network. So take that clip, send it off to people in your life, and ask them to join by word of mouth. And if you don't know what Legal AF is, that's an example. And we invite you to join us on Wednesdays and Saturdays for our live taping and then our audio podcast platforms right here on the MeidasTouch Network. So until my next hot take, until my next Legal AF, this is Michael Popak reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.